is the LGBTQI legal landscape of this country. So there used to be a section called 377, IPC 377, which used to criminalize the LGBTQI community. This section not to be decriminalized, the community will be treated as illegal and unconstitutional. Navtej Johar versus Union of India in 2018, which means the judgment goes like this. Any sort of consensual sex between two adults who are above 18 years, and between four walls is their constitutional rights, the freedom of expression, and the freedom, and also the equality in front of law for the LGBTQI people. 2026, which the Parliament of India has made for the Transgender Persons Protection of Rights Act of 2019, which has changed the whole legal landscape for the transgender people in this country and have brought many of the exclusions and lot of criminalizations for the community, which means the whole identity of transgender person is no more a self-identity. It will be dependent on the identity which will be assigned to them through the medical board, and the procedures and rules followed by gone through the medical board. There will be a medical officer who will decide the gender of a transgender person. In 2020, we are all in the COVID rush, but the government still was adamant to, draft the rules of Transgender Persons Protection of Rights Act, and they have given only 1 week, but we have written to the government to extend the time limit. They have extended to 1 month, and we have 4 virtual consultations where we have given a lot of suggestions on the rules, which has been uploaded by to the website of the ministry and asked for suggestions. So on 21st October 2020, the rules came out in an official, gazette, and Form 6 has been prescribed for every single citizen, transgender citizen of this country must apply for a transgender certificate virtually, going to the website of Ministry of Social Justice and Empowerment. They ran a transgender portal where every single transgender person should apply with a declaration saying that I'm a self-identified transgender person. My previous name used to be this, and now my name is this. I identify myself as a transgender person, and I live in so-and-so area. So that application will go through the Ministry of Social Justice and Empowerment to the district where the transgender person lives, actually, to the district collectorate office. And after the district collectorate office checking that person's, details in their data, now the district collector, the district magistrate, will issue a transgender certificate signed and sealed by their office. That used to be the procedure for every single transgender person from 2020 to 2026. So these are the various chapters and components which has been dealt in 2019 Act, which are also now in 2026. But few things have been changed. But the basic structure of the Act has been remained like this, because if there are main 8 components which deal various things in this Act: educational establishments and services, employment or occupation, healthcare services, goods and accommodation services, right to movement, right to reside, opportunities stand for holding for public office or private office, establishment in whose care or custody of transgender person may be. So this whole crux of these components are basically designed to defend the stigma and discrimination which are faced by transgender communities. For example, if any transgender person is facing discrimination, not getting enrolled in any specific educational institution, then this Act will be applicable there. If they are not allowed to be in any healthcare services just for being a transgender person, this Act will be applicable there. A person is denied for a job and occupation, then this Act should be available there. So these are designed in a way to protect that any single transgender person of this country should not be kept away out of the mainstream, formal setups which are available for very freely as a right for the male and female in the society. So I think I'm also describing here the Navtej Johar judgment, which is a very historical judgment, because this is not a relevant for this session, but I feel more relevant because while we are discussing about transgender issues, then we must also know about what is the LGBTQI legal landscape of this country. So there used to be a section called 377, IPC 377, which used to criminalize the LGBTQI community. So this session used to be go like this: any sex which is non-penovaginal sex, the sex which is other than penis and vagina, such sex are to be treated as unnatural, and that's how they should be treated. They are, whoever is practicing that, they must be punishable. Which means, like, if any person, irrespective of the sex or gender, are doing a sex other than they are criminalized under this section for an imprisonment of 10 years, and 10 years imprisonment, and also a fine of 25,000 rupees. Now, the historical, history of this section 377 is previously in the British, regime, when the British army used to keep away from their homes from years and years, and there used to be a practice of homosexuality, and that's how that has grown to many of sexually transmitted infections within the British army. That's why the British brought this law in their regime. But this has been passed over to the Indian laws as it is, and that's how the LGBT community also are being criminalized on the lines of this 377. So the LGBTQI community has a historical movement which is designed around this section to be decriminalized, because unless until this section not to be decriminalized, the community will be treated as illegal and unconstitutional. So there were a lot of cases which has been fought on the basis of this to decriminalize 377 session, which is in 2012, the Suresh Kaushal judgment, where the Delhi High Court judgment, where the High Court has said that it is not the plate of male for the parliament to decide whether the relationship between two individuals is legal or illegal based on this session. But again, it has faced a lot of pushback from the parliament also, and the parliament said that the court has to decide it, and the court said that parliament has to decide. In 2018, there was a judgment. So these are the 5 judges bench, which is called Navtej Johar versus Union of India in 2018, where the judges said that, very simply, they said that as a none of business of the state which can indulge or involve in between two individuals, which means the judgment goes like this: any sort of consensual sex between two adults who are above 18 years and between 4 walls is their constitutional rights. Okay, so the court acknowledged that irrespective of sex, gender, and sexuality, if they are above 18 years and they have a consent for having sex in between 4 walls, it's none of the business of the state to be get them disturbed. And that judgment has become a historical judgment and have open a way of freedom, the freedom of expression, and the freedom, and also the equality in front of law for the LGBTQI peoples. Next, so now I'm coming to the main amendment of 2026, which the Parliament of India has made for the Transgender Persons Protection of Rights Act of 2019, which has changed the whole legal landscape for the transgender people in this country and have brought many of the exclusions and lot of criminalizations for the community. The first change which has been brought in through 2026 judgment was like the definition of transgender person has been changed. Previously, as I said, that NALSA judgment, based on NALSA judgment, it is only the self-identity. Any transgender person can identify themselves as transgender person, can give file an affidavit for claiming a transgender certificate. But now it's only confined to few communities, cultural communities like Hijra, Arvani, Jokta, Kinnar. Okay. Now, as I said that in my introduction, I'm a trans woman. I was born in a sex of male, but I have been transitioned to the sex of female after transition surgeries and everything. And now I identify myself as a trans woman. Okay, there are also trans men who are born as a women and transition to the sex of men. Now, this definition is completely keeping out the trans men out of this definition, which is which means like the people who between 2014 to 2026, the trans men who used to be identified themselves as a transgender person are no more transgender person as per this definition because you don't recognize. India is a very diverse country, and this definition has confined the identity to only four cultural terms, which are Hijra, Kinnar, Jokti, Arvani. But there are many. For example, in Northeast, if you go, the transgender women are called as Nupi Manvi, and the transgender men are called Nupi Manba. Okay, they are not into this definition. There are also another community in Telangana, Shiva Shakti, which are not in this definition. There are many transgender women who are identify themselves as Yoginis and Shiva Shaktis. They are not into this, definition. So many of the cultural identities also kept away of this, definition. That's how they may be not be identified as transgender community people from here. Apart from that, this is so ambiguous. This definition is that irrespective of any person has been undergone the hormonal changes or have done surgeries like emasculation or castration, unless until they are gone through the certification process of medical board, they cannot be identified as a transgender persons. That was the clarification given in this definition part of the transgender, which means the whole identity of transgender person is no more a self identity. It will be dependent on the identity which will be assigned to them through the medical board and the procedures and rules followed by gone through the medical board. So this bill has created a medical authority. Actually, in 2016, you might have observed, we used to the government of India said in 2016 bill there must be gender screening. They came with a board with like a doctor, lawyer, and social work and everyone. Again, this bill also brings not only being now this become an amendment also act for that act 2019. Now this is an act. Okay, now this act also be constituting a medical board where the chief medical officer will be there or deputy chief medical officer will be appointed, and this authority will be given the important role in process of identifying a certifying transgender person. So now no more self-identity will be recognized by the government of India. There will be a medical officer who will decide the gender of a transgender person. And we don't know the guidelines of this till the guidelines haven't came out what and how it is going to be executed or administered by the governments. Changes in the identity certificates under the amendment. The district magistrate will continue to issue certificate, but with additional, procedural protocols. If we have to again, and a lot of people have not still applied for transgender certificate, then if they have to apply, then they have to first go for a checking or screening by the medical board. Will be constituted very soon. Soon the rules come into existence, and through that only any transgender person will be able to get a transgender ID card only after they go through the screening by the medical board. So, right to update identity documentation, a new provision enables individuals who receive a certificate of identity under Act to change their first name in the birth certificate and their official identity documents. This change recognizes the practical, difficulties faced by transgender person mentioning considering identity records across the official documents. For example, this provision is saying about if anyone want to change their date of birth certificate or the passport or any other valid documents, then this document which has been given by medical board and by the district magistrate after this new rules come into existence, this will become a base of them for them to change their name or a gender even in the date of birth certificate and other relevant, documents also. So there is a revision in the procedure for gender change after surgery, and the amendment also modifies the process of gender change, the medical procedures. Under the proposed provisions, the medical institution where gender affirmative surgery is performed must provide details of the district magistrate and designated authority. The individuals must apply to the district magistrate along with a certificate issued by the medical superintendent and chief medical officers. So now this fifth provision or fifth change which the Transgender Persons Amendment Act of 2026 brings is that if the transgender person is getting transition surgeries from male to female, female to male, then that details whoever doctor performs have to be recorded, have to be documented with the consent authority which the act actually prescribes or will be appointed by the guidelines of this act when they come into implementation. So there will be a data maintained whoever undergone surgery, transition surgeries by the government and also and district magistrate also, okay, through the district magistrate. Both the chief medical officer and the district magistrate both has to maintain that. And there is a change in the National Council for Transgender Persons. The amendment also modifies because now there is in 2019 Act also there used to be National Transgender Council, where according to the regional basis, various transgender activists used to be on board, and it is on a selective process. They used to be on board and they used to deal with the whatever budgeting or whatever the projects or the welfare to be rolled out to the all the transgender community throughout the country. But now the chief of this National Transgender Council will be a director level or someone from the ministry will be assigned very soon for this National Transgender Council, which means that like now Transgender Council will be under the government department, and one of the government officials who will be appointed by the government, competent government, will be dealing with the issues of national transgender. And the last but not the least, the stronger criminal penalties has been for exploiting another significant aspect of which is a significant change in this amendment. Section 18 is the one which deals in 2019 Act about the penalties on if any discrimination or violence happens to transgender persons. Now, under this section 18, there are many new subsections has been added in the new amendment in 2026. The new provisions introduced strict punishments for serious crimes such as forced labor, involving transgender person, denial of access to public places, forcing a transgender person to leave their home, or physical, emotional, sexual, or economic, abuse. More severe offenses, including kidnapping and abducting a person and forcing them to assume a transgender person identity through mutilation of medical, or medical procedures punishable with rigorous imprisonment not less than 10 years and up to life imprisonment also. So what actually the government has seen that is many of the non-trans person or children have been abducted by the community, and they have been forcefully force them to into the begging or sex work, and also often they are forcing them to sex change surgeries also, which is very illegal. So they changed the whole, penal, provisions in section 18 that a minimum of 10 years to the lifetime also if so-called trans person is under 18 years, which means if a minor is forced to be depict themselves, kidnapped or depict themselves or make themselves to be look like transgender person, and they are forcing them to be into begging or sex work, and they are forcing them to get done surgery, the punishment may go up to lifetime imprisonment also. So such strict, punishments has been brought under this present act. Yeah. Now the floor is open for the question.